afternoon, my lords.
Yes.
Having gone through the provisions of the statute, I am going to turn to ground 3. And you'll find that in the core bundle, tab 2, excuse me, page 14.
Sorry, core bundle.
Tab 2, page 14.
Yeah.
So this is the special reasons point.
Yeah.
And if we can go to the relevant CMA decision in terms of granting the extension, that's in supplementary bundle, tab 4, page 18.
Page
18.
Oh yeah. Okay, thank you.
And you'll see paragraph 2 is the records the decision to grant or to make the extension, and 3 other reasons. Taking this decision, the inquiry group had regard to the complexity of the inquiry, the need to consider the issues raised by the parties and by third parties, including the broad scope of the submissions made by the parties in response to the annotated issue statement and working papers, and the need to reach a fully reasoned final decision in the statutory timeframe. The inquiry group considers that completion of its investigation and the publication of its final report will not be possible within the original reference period. So those are the reasons that were given in the decision as adopted. You'll note that the notice itself doesn't make any reference to the so-called duty for expedition that we saw under section 103(1), but simply to the need to do more work. And before the tribunal, the CMA relied on the witness statement of Margot Daly, the chair of the inquiry group for this merger. And you'll see that in this supplemental bundle.
And there's no prescribed form of notice, though, is there?
No. But there is the obligation under section 103 to...
Yeah, understood.
But there's no prescribed form.
Sorry, where's the witness statement?
So it's tab 3.
Yeah.
And I think you can really get the meat of it from paragraphs 21 to 24, which deal with the taking of the decision. If I could ask you to read those paragraphs, please. So you'll see that there's a general description of the procedure that was followed, how the decision came to be adopted, but the crucial paragraph is paragraph 23, which confirms that the reason why the CMA thought there were special reasons was because there was a considerable volume of material to be reviewed. The witness
This was
statement-
following the hearing on the 6th of September and the additional material which was then submitted. So the hearing was the 6th. The 14th of September, this is para 19. The panel had sight of new material, and then a week later, 7 or 8 days later, 2 days later, there was a review of timing, and then a week after that, question of extension.
That's right. It was the submission of material that the CMA considered voluminous that led to the CMA's
Isn't
deciding.
that really the key to it?
Yeah.
If there's a new material which comes in relatively late on, and there may be anybody's fault. The reference, so the reference was, just trying to remember the dates, was it in June? Mid-June, 15th of June, is that right?
Sorry, was for the date from
The actual reference, when does the 24 weeks start running from?
There is a chronology in the bundle.
Yes.
15th of June, paragraph 1.
I think it's 15th of June.
15th of June
Sure.
is paragraph 1.
Thank you.
Yeah.
I'm told the chronology is in course 6, if that assists.
So this is from the 15th of June to the 29th of November.
So this is 4 months in.
So we're effectively 2/3 of the way through the original period, when there's an appreciation because of the additional material that's been, through no fault of the CMA, has landed on them, that they need more time.
We say
Sorry,
no
Councillor.
fault of the CMA, my lord, but the CMA knows that it has a 24-week period. So it has to make sure, for example, what the CMA can't do, for example, is sit on its heels for the first 10
No.
weeks. And then when...
But is it suggested that they did?
Sorry, my lord?
Is it suggested that they did?
No, I'm going to make a submission as to a submission which is a point of law, which is what special reasons can and cannot include. And to go forward, I'll get there more slowly. The point I want to make is that the sort of thing that one sees in this case, in terms of submission material, is not unusual. The mere fact that a party to a merger robustly defending its position cannot be special reasons. That's where this submission is leading. And so, in a sense, I understand what you're saying in terms of time.
Let's just think about that for a moment, because we've got section 39, subsection 4, which deals with a situation where, for example, there's a need to interview somebody who's not available. So that's to do with, as it were, the people you need to speak to for the purposes of finalising the report. So what special reasons are there? I mean, the most obvious special reason is going to be something to do with more time needed to assimilate large amounts of material.
That's so we've identified between us what the issue is. Absolutely.
Yeah.
Can I now develop the submission because I have materials to show you, etc. But absolutely, in terms of the point that your lordships are putting to me, that is what this is about.
So
I'd rather just not.
No,
If you give me a chance to develop it.
Yeah, can we take as a starting proposition? These are the facts that you're basically taking as read. Yeah, you're not challenging.
In the
them.
chronology, no, absolutely.
No.
The chronology is
So-
what the chronology is.
So if this, and you'll explain what the position is matter a lot, then I will shut up.
No, that's for you. I'm the one who has to shut up. Don't worry. I know that.
When you're being fired at by 2 members of the court.
That's fine.
You've been very quiet lately.
I'm very happy. That's what I'm here for.
So the starting premise is that, can we make the assumption that if you apply a test of just broad reasonableness, it wasn't unreasonable for a robust offence to be partaken in, it wasn't unreasonable for all of this material to be submitted after the oral hearing, the date of the hearing wasn't unreasonable, and the burden and task which was then imposed upon the CMA, which was large and extensive and would take time, was also not unreasonable.
Yes, there could be hypothetical cases where
Yes.
the CMA didn't act fast enough, etc. But
But let's-
I'm taking this at the point of principle,
Right.
not on the facts of this case. I'm taking it at the
Right.
point of principle.
Okay.
I was just going to show you, before we leave this witness statement, paragraph 10 on page 12. Where Ms Daly says, when conducting a merger inquiry, the CMA is subject to a duty of expedition. While acting as a panel member in this case, I was aware of this duty and of the need to ensure that decisions are taken as soon as reasonably practicable. But what she doesn't say is that in the meeting where the decision was taken, the inquiry group actually itself addressed its mind to the need for expedition. And the minutes seem to reflect that. They're not very detailed, but they don't record the duty of expedition being referred to. That's this bundle, tab 4, page 16. And it's items 3, 4 and 5 are the minutes that we have of the meeting at which the decision to grant extension was taken, and there's no indication that the duty of expedition was had regard to. And then if we can move to the tribunal's judgment, that's core bundle at tab 7. And if we can pick it up, please, at paragraph 305, it's page 149 of the bundle, page 106 of the internal numbering. So paragraph 305, tab 7 core bundle. And this is where the tribunal sets down its understanding of what is meant by special reasons. Section 39, sub 3 requires special reasons in the form of good case-specific reasons which justify an extension of the normal time limit. And then the tribunal's assessment is set out at paragraphs 316 to 321. 316 begins on page 151. Just to refresh your memory on what the tribunal said in relation to special reasons. And particularly important, I think, is 319 in terms of isolating the tribunal's reasoning. The tribunal says, ideally these fixtures would have been more explicitly particularised and dealt with by the CMA. Nevertheless, they support the proposition that this was an unusual case in terms of how little common ground there was at this stage of the inquiry. And then goes on to say it was both necessary and appropriate for the CMA to carry out the further investigation and analysis that it in fact did. And our submission is that the tribunal was wrong in law to find that those facts or factors come within the legal concept of special reasons as used in the Enterprise Act.
I mean, you accept 3181 is factually correct.
I don't have any criticism of it. Those were features of the case as described. What I would quibble with is whether that makes it special.
I understand. That's why I phrased my question the way I phrased it.
And that's why I answered it in a way. So this brings us to the.
Well, I mean,
Oh,
the
sorry,
point I'm
sorry.
making, if you read 318 and 319 together,
Mhm.
is that this case was unusual because of the absence of common ground at this stage, and at least on one view, if something which is unusual may very well amount to a special reason.
Well, I'm going to come on
It
to
leads to an extension.
that's where I'm moving to next to my submissions,
It's a very
which is
odd word, really, isn't it?
what is the meaning of special
Reason.
Exactly.
Special as opposed to substantial or
Exceptional, or
exceptional or
extraordinary.
something.
That's where I'm coming to.
Because the next point I was going to ask as a sort of someone not in entirely familiar territory, 3182. Do you accept that the battle lines in this particular case were broader than in a standard horizontal merger case or indeed a standard vertical case?
I think it's, I wasn't below, but I don't think anyone did an analysis of here are the last 20 mergers and look at how complex this one was as compared to that one. I think this is the tribunal. As a specialist tribunal, I accept expressing a view, but I don't think there was any forensic
It's not that,
evidence.
it's not that complicated
this
in the
case.
overall scheme of things, no.
Well,
It's a mixture of horizontal and vertical. There's an element of subcontracting. There's a degree of competitive tender at the retail level, some but not that much. I mean,
these were points we made below. I mean,
Yeah, but
it's a narrow, it's
almost
it's
how
a
it
narrow
boils-
product market. It's
it's how it boils
limited
down into a
players.
forensic process, what that means for the CMA, for the parties at the time. It could be relatively straightforward, but still lots and lots and lots of issues.
That's right. But that's why I'm just not sure this helps. That's why the point I'm making is, in this case, a particular path was followed. It led to, voluminous material. But what actually happened in this case was the CMA granted an extension because it thought it needed more time to do its work.
Yeah.
There was no outside factor that intervened. I'll come on to that. I'll show you material on that. It was simply in the process of the case.
You were going to say such as sickness or changes in competition.
I may be about to give those examples for that, yes. But you have my point. This is just internal. This is a sort of normal merger case proceeding. There's a lot of paper comes in and the CMA looks at it and says, we need more time. That's actually what's happening here. And that's why I'm not trying to make this about the facts of this case. That's when you asked me that question, I didn't say no. I just want to characterize that this is what happens in merger cases. There are cases that are easier than this. There are cases that are harder than this. But this is all just part of what the statute envisages.
Okay.
That's the point.
You may come on to this, but we're looking at this through the lens of one case.
Yes.
The CMA presumably doesn't sit there with just one case.
I'm going to put it in a wider context.
I was going to say, because the CMA might have, through no fault of its own, a whole series of things on which are driven by external time constraints,
Absolutely.
which stretch its inevitably limited resources.
It does, but
And that's not relied on in this case as such.
No, it's not. It's not expressly.
So the fact that they had an unexpectedly heavy workload and therefore, short of, they couldn't deal with it because you just couldn't employ and train up sufficient people in the time that was.
Well, to be fair, that's not the way it's put.
That's not the way it's put, but I mean, that in itself seems to me that would be capable.
Oh, I
of
see.
being
Sorry,
special
yes.
reason.
If it was as extreme as that, sorry.
Yeah.
So the only reason for asking the
Yeah.
question is not to suggest that was the case in this case,
I'm sorry.
but it was because your submissions at least have started on the footing that what happened in this case, for want of a better expression, is entirely
not-
foreseeable.
Well, I'd say not special.
Not
but-
special, but we're trying to avoid using the very statutory
I
word,
understand,
but
but
is an entirely foreseeable consequence
Yes.
of doing what you do.
yes, that's one way of approaching this, yes.
I was only just saying at the start of the analysis, I think it may be a little unrealistic to assume that you focus on each individual case as if it's just in a silo
Yes.
and don't admit any other wider circumstances if that's what you were about to do, and you may not have been about to do.
No, I am going to put it in context, but what the job of the court is to do is to decide whether this case you've seen the decision, you've seen the witnessing of Ms. Daly. Do the facts for the decision to grant an extension as set out there amount to special reasons as a matter of law?
Yeah.
The reason I put it like that is your job is not
No.
to define special reasons for all seasons.
No, no.
No, but it's,
It's actually that very narrow point, which is you see the facts here,
Were they?
where are the special reasons as a matter
Yeah,
of
but
law.
that's why, nonetheless, in answering that question, one needs to ask oneself, well, what, on your case, what would be special reasons?
And that's where I'm going to come now. I'm going to come to the question of statutory construction. What do special reasons mean? I'm not coming up with a universal. I'm going to show you that they cannot mean what happened in this case. That's the way I put it. So first of all is the wording, special reasons. If you go to the tribunal's so we're still in the tribunal's judgment, it's paragraph 302. Because there the tribunal sets out the Oxford English Dictionary definition of special and points out that it refers to out of the ordinary, unusual, or exceptional in quality or degree. So there's the wording. That's the sort of thing we're looking for. And of course, that's the starting point of any piece of statutory interpretation. Second point is the scheme of the Act. As I showed you just before the short adjournment, Parliament has quite clearly, specifically addressed itself to the need to balance the public interest in granting the CMA powers to intervene in mergers and the public interest in mergers being dealt with expeditiously. And Parliament has enacted a detailed regime relating to time limits. And in my submission, it's clear when one looks at the suite of provisions, it's quite clear that Parliament intended that the CMA should be under pressure to comply with those time limits. And certainly that extensions should not be granted as a matter of course or on a regular basis, because then they cannot be special. The third point relates to the explanatory notes to the Act.
What happens if which may be this case, the CMA having done it, having had the right number of people on the task, I don't think it suggested that they were undermanned or underpersoned or whatever for these purposes, finds itself in a situation where it just needs that extra 8 weeks in order to address the additional material with which it's been presented. What do you say should happen? That the tribunal just says, well, we can't deal with it in time, so we're not going to bother dealing with it at all. We're just going to issue our final report because that's what we've got to do.
The way that the statutory scheme is set up is that the CMA is under an obligation to do certain things, has to do them within a certain time, and has to do them expeditiously. What the Act cannot do is dictate to the CMA how to achieve that goal. It is entirely a matter for the CMA. So, for example, that might mean that the CMA has to be realistic at the start of the investigation about how quickly to go, about how much time it's likely to need. It might mean, in a particular case, that when there's a lot of volume, the CMA has to look and pull in manpower from another task. But the point is, as a matter of statutory construction, as a matter of the scheme, what you have is a very clear system, and then the CMA understandably is left as to how to meet that system. But if in a case, the CMA, for example, let's assume it's made a misjudgment at the start of a particular merger, it thinks this is going to be straightforward, and it realises 10 weeks down the line this in fact is going to be far more complicated than it thought. That is not, in our submission, a special reason. The CMA has, through the whole piece, has to anticipate problems, has to deal with problems as they arise, and has to make the system work, because that's what the Act requires.
You answer the question then. What
I'm
happens
sorry.
if at the end of 24 weeks, so on your analysis, you've got two options. Either they rush out a negative decision on the basis of such effort that they have time to put in.
Yes, they have to do the best they can in the
Have to
time
do
they
that,
have.
and then they end up in JR, and there's
Well,
a whole
maybe not.
application to introduce new evidence, and it's really
Maybe.
messy. Or they do nothing, and you say, all right, 24 weeks is up, this is a completed merger, there's nothing which prohibits it, ergo, it continues.
Well, my lord, if the CMA does nothing, then I do submit it is inevitable from the
I
Act
understand that.
that they can do nothing. So that bit, absolutely.
If they've got no jurisdiction, and if the merger's in place, it's happened, it's continuing, it's a business, you say there's nothing which impedes its continuance.
That's right, because there is no statutory power to
So that's
intervene
the-
after the time period.
So that's the horns of their dilemma.
That's right.
If you're right that they don't have the power to extend because they're just bloody busy.
That's right.
I understand the point.
Hmm.
And that's why it's quite problematic, though, isn't it?
No, I understand the problem. That's why it's so important, because I anticipated I would come to this court. And the court would say, what about the public interest in intervening in mergers? Absolutely.
There's two sides to the public interest.
Absolutely.
We understand finality, legal certainty.
That's right.
That's important.
And my point is that Parliament has quite clearly considered both of those things. And it has given a power to extend, but that must be only, it can't be generally applied in run-of-the-mill cases or as a matter of course. It can only be in special or exceptional circumstances. And sorry.
I'm sorry, Mr. Hoskins, because
No,
I'm not being critical at all, but you haven't yet actually answered the question I asked you, which is assuming that they have that they put the right number of people onto the task, and they then find themselves in a situation where 2/3 of the way through the period they're landed with a whole load of material, additional material, which is what seems to have happened here. But they realise they're not going to be able to actually assimilate that material by the deadline, the 24-week deadline. What do you say happens then? That they simply issue a final report on the basis of the material they have looked at and say, terribly sorry, we haven't been able to look at this additional material. We haven't had time. Or do you accept that in that situation there would be a special reason for extension?
In a normal case, they have to publish the best report they can in the time they have.
Right. So even if it's actually incomplete, because it hasn't actually looked at all the material that was before.
Well, in that circumstance, I would suggest that either it should have started earlier, but even if it did everything it could and this was unforeseen late in the day, or it would have to pull manpower on for a matter of weeks to get the job done. But that's what the Act requires.
It's odd, isn't it?
It's not something in the real world, though, is it?
Something unusual happened. So the CMA is tootling along quite happily, analysing the market for the purpose of the merger. And you get to 23 weeks, and it's all just about to press the button and go.
But that's not how the system works. Well, there are a series of stages.
All right, but let's assume
It's
going-
controlled by the CMA,
Okay,
not
let's-
by the
let-
merging
let's-
party.
No, okay. I don't think I'd suggest it wasn't. Let's just assume it's gone through all the stages and everything's fine, and just shortly before it's due to issue its report, there's a sudden and fundamental change in the market. For example, the merger of the merger of two other people in the market,
Yes.
or a sudden world conflict.
That's a special reason, my lord. I'll show you. That's in the explanatory notes.
I agree, but the question is, at that stage, the CMA says, look, even with an 8-week extension, which we could give ourselves, because undoubtedly that would be a special reason. I think the examples I've just chosen are special reasons. There still isn't any way on this planet that we can get a decision out in an additional 8 weeks, because we've effectively got to go back and start again. The whole world has changed. What happens?
They have to do the best they can in the time available, or they do nothing and they lose the power to intervene. There is no other possibility under the Act for an extension other than special reasons or the merging party is not
So
complying.
the only option is either simply do nothing and allow it to go by default, or do the best you can one way
That's
or
right.
the other.
That's not in a sense, that's my submission, is that's inherent in the scheme.
Yes, no, I'm just trying to understand
It's
the
not mine
scheme.
to ask, it's inherent
Your
in
point
the
is
scheme.
Parliament's done the balancing exercise.
Yeah.
It's laid down a series of rules. And it may be that at the end of that period, if nothing's happened, then the transaction is just de facto, it continues without impediment.
That's right, because in that circumstance,
Yeah, the question is within that framework, when there is all this balancing of rights and legal certainty, which are very important, but public interest on the other side,
absolutely.
what happens when you get to an inflection point after 24 weeks
That's right.
and the thing isn't ready? It's not ready for the oven.
That's right.
Um,
That's precisely, that's the hard
Yeah.
issue. And my submission, as you know, is this can't be special reasons.
Parliament's got two things in the words: if it considers, and then special, as opposed to extraordinary or exceptional.
But
You
special
could use
means out of the ordinary, unusual, exceptional.
If it were exceptional, it would clearly be special. But they didn't use that word, which suggests they intended to possibly have a broader meaning, because special would include exceptional and extraordinary, but may go
Still
beyond
out of the ordinary, though. I mean, special. If we're talking about degrees of exceptionality or
that. You're
specialness,
assuming that it's a relative test.
it still has to be something that's not commonplace. Wait, I don't know. You can draw the line where you want up from that, but it cannot be something that's commonplace. That must be uncontestable.
So if it forms the view that there's a surprising amount of discord and not the normal degree of common ground that you'd expect as you get towards the end of a merger inquiry, is that out of the ordinary?
No, you get, some mergers will be easier than this, some will be harder than this.
But then
But there's nothing
You just put it in
special.
relative terms, where
I
especially you say is beyond par.
I did because I want to say that this sort of issue, having to deal with lots of material potentially late in the day, is just part of the CMA's job. That's part of the job. And Parliament has decided to put this cliff edge into the Enterprise Act for strong reasons.
And so parties are allowed to be as complex and as difficult as possible in terms of the submissions that they make and the amount of paper that they generate.
Save them up for the oral hearing and then whack them in afterwards.
It has to be the case that the CMA must plan, given the statutory scheme, on the basis that a party will defend itself robustly.
Meaning generate vast quantities of documents with
Later
a
on.
view to pressurising the CMA. I mean, I'm just looking at the incentives here of the interpretation.
understand.
I'm not suggesting.
Well, those sorts
I'm not
of...
suggesting for a minute,
Sorry.
by the way, that this is
I
aimed
understand.
at your clients. Just let's be
Understand,
clear about
yes.
this. I'm just looking at the overall structure.
Well, if you think about the gaming the system, the point,
Yeah,
that has been anticipated in the Act through the provision that, as well as an extension for special reasons, it's possible to extend where the merging parties have not complied with the request for information or evidence in good time. So that issue of gaming has been anticipated in the Act, but only in relation to a certain facet. And my submission is, given that gaming is catered for in the Act in certain circumstances, but not this one, that tells you that the example you've given me is not intended to be a special reason, because it's a type of gaming, but it's not one for which an extension can be given.
I mean, that's not a great incentive to have lurking for the smooth operation of the system. I mean, is there any indication that Parliament was even conscious of that sort of possibility when it?
Oh, that I can't. That's an impossible question. In the sense that is there paper that deals with that? No.
No, but except it is your submission that this court should sort of effectively read into the statute that Parliament decided to, as it were, deal with one type of gaming the system because it made specific provision for it, but to allow gaming the system in a different way.
But I make that point purely as a matter of statutory construction, and that's all I can do.
Yeah.
Because can the system be gamed? Yes. How can it be gamed in this way or that way? What does the Act say about that type of gaming? Well, it deals with this one, but not that one. But that's as far as I can put it. It's a matter of statutory construction. But that's the norm. It would be unusual if I was able to come up with sort of Hansard material and say, well, look, this and this and this. It's inevitably the process we have to engage in. So
Is it relevant that it's a one cap fits all, that the 24 weeks is not differentiated in any way depending upon the size or scale or complexity of the merger?
Our submission on that is what Parliament has decided, as it said, given that mergers come in all shapes and sizes, what is the appropriate timescale for dealing with them? The 24 weeks must have been set on the basis of mergers being all shapes and sizes. And for example, there's not a statutory scheme that says it's 24 weeks unless the merger is particularly complex. It's not that, it's special reasons.
And it's relevant that there's always a period prior to the reference being made when the CMA is in possession of notification. and is doing some work to decide whether or not a reference is necessary.
That's right. So phase one
It's yes.
is there and allows the CMA to have some sight of what's coming in terms of complexity, etc., etc. That's right. So I'm still on my statutory construction. I've done wording. I've done the scheme. Explanatory notes, you have the point, but we haven't seen it, but let's get it on the record. The explanatory notes for the Act are in Authorities Bundle, tab 2, page 61. And it's paragraph 143, and Lord Justice Snowden just referred to the examples. The section permits this CMA to extend the 24-week period for the report for one further period of no more than 8 weeks, which is satisfied that there are special reasons for delay. The section does not further define special reasons, but it is anticipated that they would include matters such as the illness or incapacity of members of a reporting group that has seriously impeded its work, and an unexpected event such as a merger of competitors. In our submission, those examples are qualitatively different when compared with, for example, complexity of a merger or volume of work.
It's slightly curious. Unexpected events such as merger of competitors, I would understand that's why that's a special reason. But the fact that people in your team might be ill from time to time,
I think it would.
Is that really so? I mean, on your analysis, is that really so unexpected?
Well,
surely you should plan for it.
That has seriously impeded its work. So it couldn't be if the tea lady in the CMA is taken ill. That obviously doesn't. But if the chair...
That wasn't the example I was thinking.
No, but sorry, if the chair of the inquiry group is taken ill, then that could be a special reason. If a caseworker is taken ill, then probably not, but it depends. If they are absolutely fundamental, then possibly yes. But the point is, this is not about the run-of-the-mill mergers, all sizes, all shapes. It's about extraneous events happening that can't be foreseen.
Right.
And in relation to statements in Parliament, there was a statement made by the responsible minister during the legislative process. That's in Supplemental Bundle, tab 5.
Is this admissible?
Absolutely is, because you have Benyon in the bundle. I can take it to you if you want, but Benyon explains reports of legislative debates may be referred to outside the rule in Pepper and Hart to supply context or identify the mischief at which legislation is aimed.
Sorry.
So when we supplementary?
Supplementary, do you mean authorities or what?
No, I mean supplementary bundle. It's set out in our application to the
Tab
county,
what?
Ah, sorry.
and it's
As in the application?
tab 5.
Yeah.
And it's at page 101. Sorry, just for Lord Justice Green, I'll give you the reference to Benyon so you have it. So that particular proposition is Benyon section 24.12, page 746. It's Authorities Bundle, tab 31, page 741. And if you want the equivalent principle for explanatory notes, that's Benyon section 20.
I'm
you have that one,
in
it's fine.
explanatory notes. It's just that some parliamentary statements are treated with the contempt they deserve.
Absolutely,
and
I
others
understand
not.
that. Understand that. So you have Pepper and Hart, and you have the formal requirements there, and Benyon explains that there is this broader principle which is recognised in Benyon and is relative to the mischief. And that's precisely what we're doing here. What is the mischief? What is the reason why special reasons are accommodated? So this is at page 101, and we have set out at paragraph 252 and 253 a statement by the responsible minister. And I'd ask you to read 252 and 253, and I'll draw your attention to 2 points from that.
Yeah.
So, first point reflects what we see in explanatory notes. In the first paragraph, One reason for which an extension might be required is illness of members of the reporting groups, which might seriously impede the Competition Commission's work. That probably doesn't add anything beyond what we know from the explanatory notes. But then importantly, in the penultimate paragraph, which begins the clause is intended. So this is the mischief the clause is directed at. The clause is intended to impose a discipline on the Competition Commission that is strong enough to ensure that the vast majority of cases are completed within the 24-week deadline. Not within the 32-week deadline, within the 24-week deadline. And that shows you that in the vast majority of cases, Parliament or the Minister is anticipating there will not be special reasons.
So it's 50%. Vast majority.
Well, we say that, I'll show the point to the rest of the court and then I'll deal with the point. So if you go to page 102 in this document, footnote 293, there's a reference halfway down footnote 293 to the government's consultation paper. The government's consultation paper, Reforming Competition and Consumer Policy, etc., July 2021, confirms this power under section 39 sub 3 has been used by the CMA in approximately 50% of cases. And in almost all cases, the CMA extended the timetable by 8 weeks, even if it did not always use the full extension time. So absolutely we'd say if the responsible minister said the majority of cases will be dealt with within 24 weeks, and what is actually happening in practice is that 50% of cases are being dealt with in 32 weeks. So there is actually a systemic issue here. It goes beyond simply my client's interest in this appeal. There is a very important point about whether the CMA is properly using the power it has in section 39 sub 3 to extend its extensions for volume of work.
I mean, there's quite a big public interest, isn't it? Because if you either need more resources to do what it's being required to do, or alternatively, the risk is that if it can't justify extensions, it'll be doing an inadequate job and everybody will be tied up in appeals and judicial review, or things will be going through that shouldn't go through.
If that is the case, if that were to be the case, then that is not a job for this court to rectify. That is a job for the CMA to take up with Parliament. And I showed you in the Act that the Secretary of State does have power to alter those time periods.
Only downwards, not upwards.
Only downwards, not upwards. Parliament's thought, you know, it's seen this coming, but the pressure it's put on the ability.
Where we are now coming, but I agree with you. It certainly.
But it's seen the
saw something
possibility
coming,
of the need to change the time limits. And what it's certainly not saying is, if you need longer, the Secretary of State can't do it by order. If you need longer, that has to come to Parliament and go through that legislative process.
The point has been made that this legislation is 20-something years old. And I mean, I apprehend that the level of complexity of business life and competition law in particular is much greater now than it was 20 years ago, and indeed the facility of parties to generate swathes of material has increased rather than lessened.
But the answer to that...
You say that's not for this.
It's not for this court.
It's if we think it's tough, that's for Parliament to do.
If you were to rule on special reasons and rule in our favour, and the CMA to find itself in difficulty, it would have to go to Parliament. But it's correct that it should, because the Act envisages that that is a matter that needs more than just a Secretary of State's order. It needs to be considered and debated properly by Parliament.
So you must be right that if you're wrong about what special reasons means, well, irrespective of whether you're right or wrong, we can't, as it were, remedy the mischief.
That's right.
I mean, if there is a mischief, which it seems there may very well be, if it's true that 50% of them are cases where there's an extension, then it may be that the time frames need to be reconsidered, but they'll have to be reconsidered by Parliament.
That's the point.
So your point is, don't adopt an otherwise inappropriate interpretation of the word special to do somebody else's job for them.
And that would be wrong I mean, I don't sound all sort of highfalutin, in the constitutional scheme,
Absolutely.
it's not your job, and I mean that in not a completely non-pejorative and
No,
respectful
carry on.
sense.
Don't worry, we understand the point.
It's always wise to tread carefully.
Okay.
I mean, it's interesting because if we just go back to the tribunal judgment, again, just for a sort of last bit of context. So the judgment is core bundle tab 7, and it's paragraph 316.
316.
That's right, on page 151. What the tribunal said was, merging parties can be expected to respond at length and in detail, and with further and more particularised materials, including economic and survey evidence, through the course of a phase 2 investigation. This is particularly the case where they have the sense that they have a prima facie case to answer, while the CMA is taking a markedly different view of the issues than they are. The investigative process needs to be flexible enough to accommodate that. And we absolutely endorse that observation. Parliament was aware of that, the all size fits all, and it adopted the scheme it did. We then, of course, say the tribunal went awry, but that observation is absolutely correct. So for those reasons, we say that the reasons in this case for the extension, as you've seen them in the notice, the first witness statement of Ms. Daly, the minutes of that meeting cannot be special reasons as a matter of law.
Can you
and
just
that's ground
just pulling threads together, define the essential features of something which is special? I think you used the word extraneous. What are in your submission those critical defining features which make the facts here fall on the wrong side of the line?
I'll go back to the Oxford English Dictionary. They have to be out of the ordinary or unusual. I won't even go to exceptional because we've had that discussion. Out of the ordinary or unusual. But in a case in which a party defends itself robustly, in a merger case, that's not out of the ordinary or unusual. That's to be expected and anticipated. So I answer your question in the negative in that way. Because I don't have to come up with a universal definition of LGU. It's simply, will this do? The sort of thing we see in this case.
Okay, we have to think about this. What would happen if, unbeknown to the CMA, the appellant had deliberately held back its submissions so as to deluge the CMA after the hearing, kept its powder dry? The CMA doesn't know that. There's no appearance of games being played, but that's what happened.
If there was actual proof of gaming, we'd have to have that, we'd be in a different case, we'd be making that submission. I can see that's a more difficult case, but I just have to deal with this case. In my case is, okay, there are certain complexities, but this is not that sort of extreme case you've put to me. And that's all I need to address. So that's ground 3.
Yeah.
Ground 4, you find it in core bundle tab 2. Page 14. The tribunal committed an error of law at concluding that even if the CMA's extension had been unlawful, the decision, which was out of time, was nevertheless valid unless the tribunal exercised discretionary powers to quash it. So here, we're in a world where the CMA did not have special reasons to extend the time period for its investigation. And the question then is whether the tribunal, nonetheless, had discretion not to block the CMA's decision in the FR, to allow it to take legal effect and to allow the remedies to take legal effect. And to show you what the tribunal said about this, it's core bundle tab 7, para 336, page 158. So you see at 336, it sets up the premise I've just explained for ground 4. No special reasons. Is there nonetheless discretion in the tribunal to save the FR. And then the conclusions of the tribunal are at 339 and 340 towards the bottom of the page. So you see it refers to section 120 of the Act, which we'll come to shortly, and says that the tribunal would have discretion not to quash the FR, even if the 8-week extension had not been lawfully granted. And as a matter of legal principle, how do we approach this question? What's the correct framework for analysing this? And we say it's a matter of statutory construction. If I can take you to Authorities Bundle, tab 6. And it's the case of the Queen and Soneji and another, it's the House of Lords case from 2005. And this, I think it's probably worth, if you don't mind reading the head note to yourself, just from D to H. It's obviously a completely different statutory framework, but it will help put the principle in context. And this issue was a problem that troubled the courts over the years. And actually what you find in Soneji is the House of Lords resetting the approach to be adopted. If we can go to the speech of Lord Steyn at paragraph 14 on page 175. And I ask you please to read paragraphs 14 and 15. And then if we can go please to paragraph 21. Again, I invite you to read 21 and then 23. Then one more authority, tab 15. The Queen on the part of Haworth against Revenue and Customs Commissioners. I don't think we need to go into the facts on this one. There is a statement of the law, page 443. Lord Justice Newey, paragraphs 55 and 56. And if you could please read those paragraphs.
You say Parliament's done the balancing exercise.
Can I wait for the other two, sorry. But yes. You'll get me into trouble. So what are the consequences in this case if there isn't a discretion for the tribunal to save? It's that the CMA has no power to intervene in the merger or to adopt any remedies in relation to merger. That is the consequence that's talked about in Lord Staines' judgment for our case. But absolutely, as Lord Justice Green just said, it's quite clear that Parliament, that the Act does envisage that cliff edge, because it's quite clear from the Act that if the CMA doesn't adopt a report within 24 weeks and doesn't grant itself an extension, it will have no power. It's quite clear that in a situation where the CMA does grant itself an extension of 8 weeks, but then fails to adopt a report within that time, it will have no power. And our submission, given that Parliament has clearly anticipated and accepted that consequence and legislated for it, the same must apply in a situation where the CMA has granted itself an extension of time, but has done so unlawfully. So we say, if you take the test in Haworth, at H, the first is to ask the question identified by Lord Staines: did Parliament intend total invalidity to result from failure to comply with a statutory requirement? If the answer to that question is yes, then no further question arises. And we say the answer here is clearly yes. And let's see, the tribunal of course disagreed with that, and let's now look at why the tribunal disagreed, because it relied on section 120 of the Enterprise Act, which is in tab 1 of this bundle at page 57.
Yeah.
You pick it up at 56, 120, review of decisions under part 3. And this is just the general provision that sets out the remedy in relation to merger decisions. Review of decisions under part 3i in relation to mergers. Any person aggrieved by a decision may apply to the Competition Appeal Tribunal for a review of that decision. And then sub 4, you have to apply judicial review principles. And then sub 5, the Competition Appeal Tribunal may dismiss the application or quash the whole or part of the decision to which it relates. And the tribunal relied on that provision to say, look, the Enterprise Act does give discretion to the tribunal. However, section 120 is a general power of the tribunal when conducting a review. What I've shown you is a detailed scheme relating to the time limits. And with all due respect again to the tribunal, there's absolutely no way that this sort of general measure can trump the detailed provisions that are in the Act relating to time limits, with the clear consequences that I've shown you. And that's where the tribunal went wrong.
The word may has to factor in the analysis we've just seen. In some cases, even Haworth there's a power, but in other cases, the may would have to be exercised in one direction only.
when you're looking at, if you're adopting the approach that Lord Steyn required and subsequent decisions, you're having to interpret the Enterprise Act as a whole, and that includes the time limit provisions in section 120. And my point is the general
Those have to
120
be-
cannot trump the specific.
Yeah, those have to be,
That's the point.
yes, I think that's the analysis I'm putting to you.
Sorry.
May doesn't mean may in every single case, because there's some circumstances where though you have a power, it can only be exercised as a matter of
In
law in
one way.
one direction.
Absolutely. Yes, the tribunal's power could be, its hands could be tied by other provisions in
But
the
isn't
Act.
it, you have to read 4 and 5 together, don't you?
Yes, absolutely.
Section 4 and 5 together.
That's
Where,
right.
in this given situation, what are the powers of the tribunal by way of judicial review? If the answer to that question is, well, this is a situation in which, given that there is a failure to comply with a mandatory requirement, then
That's right.
what follows is quashing.
And that's the whole premise of the cases we've been looking at, because in judicial review, there is always a discretion to grant remedies. But what the case law tells us is you have to look at the scheme of the Act first and see where the Parliament intended that discretion to be available. So I think we're absolutely in the same place, at least in that as a premise. And that's ground 4. Ground 5 is the final one. If we go to core bundle, tab 2, page 14. Ground 5. The tribunal committed an error of law in exercising its supposed discretionary power not to quash the decision in a manner which was irrational. So ground 5 arises where the court has found that the CMA did not have special reasons to grant itself an extension, but has also found that the tribunal nonetheless has a discretion to refuse to quash the final report. And obviously ground 5 doesn't arise at all for your consideration if you're with me on grounds 3 and 4, because then there will be no discretion to be exercised. Let's see what the tribunal said about this. This bundle, tab 7, it's paragraphs 341 to 342 on page 159. That's internal numbering 116. If I can ask you to read those two paragraphs, please, 341 and 342.
Yeah.
So you see the tribunal held that if it had found that the CMA did not have special reasons for the extension, the tribunal would nonetheless have exercised its discretion to refuse to quash the FR, i.e. to allow the CMA to intervene in the merger and to adopt remedies. Again, let's look at what the relevant legal principles are when addressing this ground. And if we go to Authorities Bundle, tab 9, it's the Queen on the application of Edwards against the Environment Agency. House of Lords, and I'd like to look at the speech of Lord Hoffman at paragraph 63 on page 225. And I invite you to read paragraph 63 and then I'll make 2 points in relation to it. So the 2 points I wish to flag are opposite E. In most cases in which a decision has been found to be flawed, it would not be a proper exercise of the discretion to refuse to quash it. It would take special reasons, if you excuse my phraseology. And at H, both the nature of the flaw in the decision and the ground for exercise of the discretion have to be considered. And in our submission, the tribunal failed to have regard to these principles in its judgment, and it therefore committed an error of law. And in particular, it failed to take any account of the nature of the flaw. Just to make that good, in relation to the nature of the flaw, remember, if we get to ground 5, we're considering a situation in which the CMA did not have any power to produce its final report after the 24-week time limit. We're inevitably there if we're considering ground 5. And that's the nature of the flaw in terms of the case law. So even if you're against me on ground 4 and were to find that the tribunal did have a general discretion to refuse relief, I think it would be undeniable that the need for the CMA to comply with time limits as set down in the Act is an important part of the statutory scheme. And just to step back, what are we talking about here? We're talking about allowing the FR, the final report, to stand in circumstances where the CMA had no power, no statutory power to adopt its FR or to impose any remedies. And that would be an extraordinary exercise of discretion in those circumstances. And the prejudice to the merging parties would be very significant because they would be required to unwind a merger in circumstances where the CMA had no power under the Act to make such an order. Just have to put it in those terms, and you see that this cannot be an appropriate case for an Edwards type of discretion. Just final, very brief observation. I mean, this isn't a case in which if you find for us, find for Cérélia, in relation to grounds 3, 4, or 5, you're somehow opening the floodgates to lots of inappropriate mergers going ahead. We've already canvassed this in some of the discussion between bar and bench. I mean, what will happen is that the CMA will have to tighten up its Act to make sure that it complies with the time limits set down in the Act as Parliament intended. And a judgment in our favour would almost certainly put an end to the CMA's current practice of granting itself an extension in around 50% of the cases before it. Because that's clearly not how the system was intended to work by Parliament. Something is going wrong at the moment. And so we say, far from being sort of floodgates, terrible mergers will be allowed through, a judgment in our favour would clearly be a good thing, given the public interest in the Enterprise Act in ensuring that merger inquiries are conducted as expeditiously as possible. And as we've already canvassed, if the current legislative scheme is no longer appropriate for whatever reason, there is a procedure for dealing with that, but it's not this court. Well, unless you have any further questions for me, those are submissions on the part of Cérélia.
Sorry, I did want to go back.
No, absolutely.
Just looking at special reasons. You pointed out there were 2 limbs. One is if it considers, and the second is there are special reasons. What do you say about whether there's any significance to be attached to the words if it considers? It seems to me that there's 2 possibilities here. The first is those words mean nothing in particular other than the fact that it's obviously it's the CMA which has the power, therefore in a sense it has to be that it considers. So it's not intended to add anything. And the actual only test is are there or are there not special reasons. That's one possibility. The other possibility is that there is some import to those words. Does it mean that there should be a greater degree of deference to the CMA's judgment as to what are special reasons, provided it's not acting for the wrong purpose or irrationally? Is it a rationality test that we're applying here, or is it just an objective question of were there or were there not special reasons, and the fact it's the CMA doing the considering is neither here nor there? How do you read that?
But this form of wording is commonplace. In public law cases, one sees it all the time. And what this means, here as in other contexts is there are two elements to it. First of all, the CMA must actually consider, believe, sometimes the word believe is used, etc. There's different formulations, must actually have that belief.
Yeah.
Secondly, the belief must be correct in law or justified on the facts. So if, for example, the CMA considers that there are special reasons and as a matter of law there are not special reasons, it's quite clear in public law that that can be dealt with by the courts. Now, you go back to sort of classic cases like Thameside, which we don't have in the bundle, but we do have a reference to it set out in one of the other cases. So I'll take you to that so you have that sort of legal principle there. If we can go to core bundle tab 7.
Supplement.
I'm sorry, authorities bundle tab 7.
Is this Thameside?
We don't have Thameside in the bundle, so I'm going to show you. Sorry, I'm so sorry, it is core bundle tab 7, it's the tribunal judgment. I was right the first time.
It's in the tribunal judgment.
It's in the tribunal judgment, sorry. It's page 66.
Yeah.
And so this is 48, it's the tribunal setting out from IBA Health. But the particularly important provision which refers to Thameside is at paragraph 93 of the quote. So you see that at the bottom of the page. The present case is not concerned with questions of... I'm so sorry.
I have lost you simply because I'm...
Yeah, it's internal page 23 if that helps.
Internal page 23.
Of the tribunal judgment. And para 48 of the tribunal judgment. And there should be a quote there, Lord Justice Carnwath, etc. And it's the final paragraph of that quote. The present case is not concerned with questions of policy or discretion, which is the normal subject matter of the Wednesbury test. Under the present regime, the issue for the OFT is one of factual judgment. Although the question is expressed as depending on the subjective belief of the OFT, there is no doubt that the court is entitled to inquire whether there was adequate material to support that conclusion. So that was a different statutory situation, but it's the same sort of setup. The OFT has to believe a certain set of facts in order for a power to do something.
So you said that the if it considers is just simply requiring it to be a belief that was genuinely held.
Correct. It must actually hold that belief.
But nothing more than that.
That's right.
On the special reasons, it's not simply for this court to say there is only one sort of black-white test of special reasons. This talks about whether there was adequate material to support the conclusion.
That's because it was a factual trigger in that case. So that's why I say it's a bit different if the OFT has reason to believe a certain situation exists. Here, the way I'd put it here is if the CMA considers there are special reasons, and our submission for all the reasons I've given you, special reasons must have a legal definition.
So you say it's a black-white,
That's
yes,
right.
no answer.
That's right.
It's whether we can take a view as to whether there's reasons
Absolutely.
identified were special or not, and that's the answer.
Yeah.
To put it in a sort of commercial context, if you like, it's a bit like a mixed question of fact and law, where you've got to apply law to particular facts. But that question is a question in itself, a question of law that can be appealed, for example, if the appeal is on a point of law.
And the second question in its props, it may well be that would be better directed at the CMA, but your side didn't object to the evidence which we've seen came in to elaborate upon the statement that was made in the notice. I think the tribunal took the view the notice was pretty sketchy, but as a matter of general practice, is that an appropriate way of proceeding? I.e. that the decision maker can supplement their stated reasons by evidence given after the event.
I'm going to give you an answer that you'll hate, and I apologise, which is it depends. Again, this is a sort of common issue that comes up in public law cases, and the parties sometimes fight hammer and tong, about whether you can and should supplement something or not. But I can't give a one-size-fits-all answer. But you're absolutely right, we didn't object in this case.
Because the basic principle is the decision maker can't supplement
That's right.
the reasons of the decision by new evidence in front of the court because of the risk of being self-serving.
That's right.
and the tribunal, I think with some justification, made the point that the statutory notice was thin, would it politely.
Correct.
On the other hand, in this case, there was no dispute that the witness statement was an extrapolation of the notice, and it was accepted as admissible, and its accuracy wasn't challenged. So the Ermakov point doesn't really arise.
I think that's right. And to be fair in this case, I mean, my submission that the statement doesn't actually add anything
No, but
in terms of the reasons.
the reason I was trying to dig a little way,
Sorry.
and my lord's just put one of the sets of reasons to you. The other one is that you've placed a lot of store, obviously, on this cliff edge, as you pointed out, and the very limited circumstances in which it was intended by Parliament that it should be capable of being, that the provision to extend should be capable of being used.
Yes.
Special means special out of the ordinary, not run of the mill, etc., etc., etc. One of the reasons to require a decision maker to give detailed reasons is usually to make sure that their process of reaching the answer they've reached is sound. I think you presumably say that that is especially so in this type of case where Parliament has intended there to be only limited extensions, and so forcing somebody to give reasons fully in the notice and holding them to it would reinforce the regime rather than undermine it.
Absolutely. I mean, the tribunal made the criticism of the reasons in this particular case and said that the CMA going forward should give better reasons. But absolutely, the duty to give reasons is not in a vacuum. It forces the decision maker to address the relevant issues and to properly articulate its conclusions on the relevant issues. So it's a powerful disciplinary tool. So there's one point a point I may have missed, but can I just take instructions?
Of course you can.
I've done my job, and those are our submissions. Thank you.
Yes, Mr.
My Lords, I'm going to begin, if I may, with some general principles about the approach on judicial review and the rationality standard. This was not the subject of great dispute, but in the judgment, which is tab 7 of the core bundle, paragraphs 47 onwards, the tribunal rather, provides a summary of the applicable standard and intensity of review, followed from paragraph 52, specific considerations to the rationality test, running through to paragraph 60. To say none of this, as I understand, to be in dispute. We see reference at paragraph 48 to the IBA case, decision of this court, notwithstanding its specialist composition of tribunals to apply the ordinary principles of judicial review. And at 49, reference to Lord Justice Carnwath and IBA, citing the remarks of Lord Radcliffe in Edmonton Bairstow. It's not a single second opinion when there's a reasonable ground for the first. Familiar territory. Then at 50, from B Sky B case, in a review under section 120, it's not permissible to seek to persuade the tribunal to reassess the weight of the evidence and in effect to substitute its views for those of the Commission. And Stagecoach at 51, the fact that the evidence might have supported alternative conclusions, whether or not more favourable to Stagecoach, is not determinative of unreasonableness, and we must be wary of an attempt to pursue a challenge to the merits. So that leads into a discussion of rationality, which in my submission can't be entirely separated, in fact, from the question of standards and intensity of review, because standards and intensity of review can't exist in some kind of vacuum separate from the legal test. The legal dicta on intensity of review does not at any point provide a legal test. Rationality is the legal test here, and in particular it was the ground upon which what is now grounds 1 and 2 were pursued before the tribunal, and indeed, as I shall come on to, in fact, ground 3 as well, contrary to what my learned friend has just submitted to my law. But on rationality, again at 52, going back to IBA and endorsing this court's position in B Sky B, it's not the tribunal's task to reassess relative weight. The task is to assess whether the Commission had an adequate evidential foundation for arriving at the factual conclusions that it did, in the sense that on the basis of the evidence before it, it could reasonably have come to those conclusions. And that is the essence of the rationality test as to be applied here. We bear in mind, as has been set out, that weight is a matter for the decision maker. The question for the court on a rationality challenge is, was there an adequate evidential foundation? What does adequate mean in this context? Again, that's not an invitation for the tribunal to substitute its own view of the merits of the evidence, but to check whether there was evidence which was probative of the issue and so capable of supporting rationally the conclusion which was reached on the basis of it. You get that at paragraph 53 from the reference to the tribunal's decision in BAA. The tribunal there presided over by Mr. Justice Sales, as he then was, setting out in what has become something of a locus classicus within the tribunal, at least, the principles to be applied on a judicial review. Subparagraph 4 there, it's a rationality test which should be applied to judging whether the CC had a sufficient basis in light of the totality of the evidence available to it for making the assessments and in reaching the decisions it did. There must be evidence available to the CC of some probative value on the basis of which the CC could rationally reach the conclusion it did. And then at 6, despite the specialist composition of the tribunal, it must act in accordance with the ordinary principles of judicial review. That's harking back to IBA. And that is the test which the tribunal applied in this case. It was careful to be clear as to the circumstances when it said, well, it could reasonably have reached a different view, but that is not a basis for overturning the decision it did reach. There was evidence which was capable of rationally supporting the conclusion which the CMA reached. So when one, in this context, raises questions of intensity of review, and is this a low intensity or high intensity review, my short answer to that is that it can be misleading to look at through that lens, because the legal test is that which I've shown you. It is high intensity in the sense that the whole point of having a specialist tribunal is to have an informed tribunal which is capable not only in reviewing the detail of the evidence that was before the CMA, but understanding its significance, understanding also the nuance and subtlety in the conclusions which the CMA has reached upon that evidence. So it's an informed reader rather than a lay reader, but it's still applying that fundamental test. So that is the basis upon which the tribunal reached that task. We bear in mind...
Can I just check one thing? Because there's sometimes some confusion in the expression intensity. Some people say it rather reflects, if you like, the forensic approach of the court. I think there's 2 stages, and I don't think you disagree. This is a specialist tribunal, and you would expect it, when it sees the evidence, to roll its sleeves up, understand the evidence, evaluate it, but then, once it's got that proper and detailed understanding, to apply the appropriate margin of discretion and say we're not substituting our own view for that of the CMA. We're checking to see whether the evidence base in the decision is adequate.
Yes, I accept that with one caveat. The word evaluate it could have a range of meanings. It is not its job to reach its own factual conclusions on the basis of that evidence or attach its own weight to that evidence. It needs to understand that evidence. It needs to understand what the CMA made of that evidence. And it needs to satisfy itself that it was relevant to the issue which was being decided and capable of supporting the conclusion.
Fair enough. Would you accept this? That if, let us say, the CAT is examining a note of a call, we've seen some of them, and it is plain from the text of the call that the CMA has misunderstood it, that the CMA wouldn't say they've made an error. What was clearly meant by X retailer was as follows. That's as plain as a pikestaff. The CMA misunderstood it. That's an evaluation, but it's the inference drawn from a document which is not in dispute. On the other hand, if the CMA is evaluating 10 different strands of evidence, all of which are moving in potentially different directions, and is trying to balance them, then the approach of the CAT is far, far less inferential. It's going to say, we're not the decision maker. This isn't a situation where we can infer anything. It's up to the CMA. I mean, is it, the inferences the CAT draws is going to be very much fact and context specific.
Yes, and in the
Would you say yes, do you agree? Or
no, I accept the proposition that Michael puts to me. In a case of clear misunderstanding of a document, well, that document wouldn't, properly understood, be capable of supporting the conclusion if in fact it was to contrary effect. So that would still fall within the rationality rubric, and the specialist composition of the tribunal means it's in a good position to judge. May well be in a better position to judge than if it were a wholly lay tribunal, if I can put it that way, whether or not that document has in fact been misunderstood or whether it does bear the meaning to which the CMA has ascribed to it. So within that context, we see the relationship between, yes, sleeves up, informed tribunal, specialist tribunal, but applying on these applications a public law test.
appropriate reticence.
With appropriate reticence. So that is the legal context. I want now, if I may, to make a series of what I'm going to call framing points, which are going to be relevant to each of grounds 1, 2, and 3, about the wider context that the points which are the subject of challenge in this case are to be assessed. I'll then deal specifically with bells under ground 1. My learned friend, Mr. Bailey, is going to deal with ground 2, recognising the recent missive from the Senior Judiciary encouraging advocacy opportunities. So Mr. Bailey is going to do ground 2, and then I'll return, if I may, for grounds 3, 4, and 5. So the framing point, so the context in which, and this is particularly relevant to the Bells and Henglein points, but the context in which the CMA is assessing this limited competitive constraint as it found them to provide. The first and most important framing point I want to make is this. The word limited in this context is not some form of term of art. It's a simple label, a simple shorthand. In this context, it simply means that the alternative sources of supply would provide some degree of constraint, but not a strong enough one in all the circumstances of the case to constrain the merged entity post-merger to the extent that no SLC is likely to arise. And that evaluation of the strength or otherwise of that competitive constraint doesn't happen in a vacuum. It happens in the context of the countervailing considerations, if you like, the main reasons why the CMA is concerned about the effect of the merger in the first place. In other words, it is identified on this, as I'll show you, this horizontal unilateral effects theory of harm, that removing one competitor from the market by merging it with another, in particular the two market leaders, the market leader in the branded channel and the market leader in the PL channel, and putting them together will remove an important form of competitive constraint on those parties, with the result that prices may rise, quality of the product may be degraded, service levels may drop. Were it not for, and then you get on to the next question, the effect of alternative sources of supply, which will still provide that constraint or not. But the strength of that constraint that alternative suppliers must find, may present, has to be assessed, if you like, as one side of a two-sided coin, which is the strength of the effect of the two parties merging. My own friend took some care at the beginning of his outset, perfectly fairly, to make plain that his target was not, as he put it, at the periphery of the decision, but was a central matter. Don't dispute that even slightly. But of course, what we bear in mind as the target of his attack is a conclusion that the constraints posed by Bells and Hengein, not non-existent, not immaterial, but limited. And what that means was insufficient as a matter of degree to counteract or protect the consumer, notwithstanding the loss of a major competitor in the marketplace, or the loss rather of a source of competitive tension. And so I do want to show you exactly the nature of that harm that was prospectively and provisionally found prior to consideration of alternative sources of supply, because it does cast a light on why it is that I say the CMA could rationally decide that Bells and Hengein only provided a limited constraint. An appropriate place to start is in the final report at tab 10 of the core bundle, with the finding on what the product market actually was, and that is at bundle page 282, internal page 117.
Yeah.
Paragraph 858, because see, these are the conclusions. There's been a preceding discussion, of course, but these are the conclusions. In summary, we consider. I'm just going to ask you to read A in particular, including Roman 1, Roman 2, A. There's various other factors which follow at B through to D as to why various other products or services fall inside or outside the market. But the key point here is that although there are two channels, branded and PL, products supplied are part of the same product market, which means you find the definition of the product market at 860 on the following page. The impact of the merger should be assessed in relation to the wholesale supply of all DTP products, both chilled and frozen, both branded and PL, to grocery retailers. Now that conclusion, of course, is not the subject of this appeal, but it's important to understand that that conclusion had been controversial at the investigation stage. If you turn to page 268, internal 103, paragraph 8.2, you can see the parties' submissions on market definition.
So sorry, just give me that paragraph number.
It's 8.2.
8.2. Thank you.
Because their case was that these were not competitors at all, the parties. There were two distinct vertically related economic activities: upstream manufacturing of products and downstream brand ownership stroke operation. and they submit that Cérélia doesn't operate in the downstream market. Instead, it's the retailers with their private label brands that are active at this level of the supply chain, operating as brand owners and competing with Just Roll.
This is the argument that it was really the retailers who were competing with Just Roll.
Yes. On a different market to Cérélia, which it said was competing in a contract manufacturing.
Just manufacturing, yeah.
And it manufactured both for supermarket brands and for brands such as Just Roll. That's the argument. So they said, we are not competitors. We're not even in the same market. We're doing different activities. And our relationship is purely vertical and not horizontal at all. This is laying some of the groundwork for when we come back to ground 3, but you're going to see it's also relevant to the way the case is even put now in this case an argument on grounds 1 and 2. And so they identified what you see at 8.3 was referred to throughout by the parties as the conflation error, by conflating these two levels of the supply chain into a single homogeneous activity. Now we know all that was rejected by the CMA, and as I say, there's no surviving challenge to that before this court. But just for your note, you can see the CMA's reasoning for rejecting that at 8.9 through to 8.25, where you see the consideration of the parties' activities and the reasons why they consider all these products now within a single market with both parties competing against each other on a horizontal basis, albeit there was the quirk of a vertical element in that Cérélia was still manufacturing most, although not all, of Just Roll's products, a fact which had to be borne in mind throughout the analysis and indeed was. So that's the starting point, is that they do compete within the same product market. And that, of course, explains, therefore, once you establish that horizontal relationship, why the CMA's theory of harm was based upon horizontal unilateral effects and not a vertical foreclosure theory of harm, as between contract manufacturer and brand owner, as the parties had argued. And that was so notwithstanding that they competed through different channels. So the CMA rejected the merger parties' claim that they were not competitors at all. It rejected the claim that Cérélia was simply a contract manufacturer competing against other contract manufacturers, and that Just Roll was simply a consumer brand competing with supermarket brands. And it rejected Cérélia's assertion that the merger should be analysed through the lens of a vertical merger, as I've indicated. So then you come within that context to the competitive assessment and the approach to it, which you'll find in chapter 6 of the report. And I need to take you to paragraph 6.5, which is on page 216, or internal 51. And I won't read out, just ask you just to cast an eye on 6.5 and 6.6, noting the differentiation between the parties, differentiated in other words between the branded products and the own label products, and the fact they take into account the pre-existing vertical relationship. Then you get to the role of the market definition, 6.10. Close attention to the roles of the parties. And then the framework adopted is horizontal. That's at 6.11. Bearing in mind, I've given the reference there, chapter 8. I think that reference deals with that more fully. But we nonetheless consider the last two lines of 6.11, the horizontal framework is appropriate to assess any competition concerns. And that takes us on to the theory of harm on the next page, beginning at 6.15. And the framework provided. What happens at 6.15 is two crucial paragraphs from the merger assessment guidelines, or the MAGs, which are duplicated here in effect, and duplicated also in the tribunal's decision, which set it out all fully. At 616, citing paragraph 4.1 of the MAGs, a basic explanation of when horizontal unilateral effects can arise. And one firm merges with a competitor that previously provided a competitive constraint, allowing the merged entity profitably to raise prices or degrade non-price aspects, such as quality, range, service, and innovation. Unilateral, without need to coordinate. Unilateral effects giving rise to an SLC can occur in relation to customers at any level of the supply chain, for example, at wholesale or retail or both. Is not limited to end consumers. And then going on to quote from 4.3 of the merger assessment guidelines in the following paragraph, the concern under horizontal unilateral effects essentially relates to the elimination of a competitive constraint by removing an alternative to which customers could switch. The CMA's main consideration is whether there are sufficient remaining good alternatives to constrain the merged entity post-merger. And then a series of examples are given as to where competition concerns are likely, all of which we'll see were met in this case. Where there are few existing suppliers, that will be met in this case. The merger firms enjoy a strong position, that is met, or exert a strong constraint on each other, that you will see is met, or the remaining constraints on the merger firms are weak, that you will see is also met. Competition concerns are likely. Furthermore, in markets with a limited likelihood of entry or expansion, any given lessening of competition will give rise to greater competition concerns, and that we will see was met. So the analysis of whether existing alternative suppliers are sufficient to constrain the merged entity has to be seen as one piece, an important piece, I don't resolve from, but one piece of that overall assessment as to whether an SLC arises under this theory of harm. And that is why at 6.18 you see the structure of what then follows in this decision, which is worth understanding. First of all, consideration of the nature of competition, but then of the closeness of competition between the parties, and then C, the target of my learned friends attack, the strength of any alternative competitive constraints on the parties, and the nature of any harm arising from the merger. Obviously, whether or not the conclusion that the strength of any alternative competitive constraints on the parties would be limited was rational has, for the reasons I have indicated, got a strong interplay with each of those other factors. It's not an absolute standard which stands on its own. So that requires an assessment of the evidence, requiring a large measure of judgment as to the strength or otherwise of the constraints imposed by identified alternative suppliers when set against the strength of the merger firms, including to the extent to which they exerted a constraint on each other before the merger. That's the judgment which is being performed by the CMA. And as a high-level point, I simply submit at this stage, that's not obviously fertile ground for a charge of irrationality. So the first of those factors at 6.18 was the nature of competition between the suppliers at the wholesale level. And you'll see at chapter 7 of the report, which starts at page 242, internal page 77, that there's a section, features of the sector in our competitive framework. And again, I need to show you just some aspects of this, which I'll do as quickly as I can. But 7.8, it's on page 244, internal 79. Uh, 7.8, 7.9 provides the link between retail demand and wholesale demand. The basis that grocery purchasing decisions are informed by what their customers want to buy. One retailer giving evidence of that and another doing the same. So grocery retailers are responsive to the demand preferences based on the quantities being bought, and that being corroborated, more quotes. And then so 7.9, as a result, the CMA is of the view that competition at the wholesale level is linked to the competitive dynamics at the retail level. That is, the demand for products at retail level significantly influences the amount that grocery retailers purchase. So a derived demand. And then at 7.10, but beyond that, purchasing decisions are also informed by broader commercial and strategic considerations, including shelf space, the profitability of the product, the desire to provide choice, and the importance placed on innovation. And then at 7.13, an important point which is developed at further length below, that retailers that stock both won't necessarily do so across their full range of products and regularly change the amount of product they purchase across each of the channels over time, as detailed below at 7.30 to 7.40. And they may even go so far as to delist a product entirely. But what is more regular is that flexing of volumes of products across each of the channels. Whilst we're in this section, I need to cover on page 246 the PL supply process because of one of the submissions made by my learned friend, to which I'll return. But you'll see at 7.20, Cérélia told us that negotiation of pricing and terms for PL DTP products, and you can see what it then follows in highlight. And you can see at the top of the next page what is said about only 3 particular groceries, how they source the supply of PL services. And then the other retailers tend not to do that. And instead you can see what they do. The end of that paragraph.
Yeah.
And just for context, those 3 retailers, if you keep that in mind, who they are, if you turn back to electronic 213, or internal page 48, sorry, other way around, I'm so sorry. Bundle page 213, internal page 48.
So not electronic.
Not electronic, I'm so sorry. I wish I had that. If I had the electronic number, I'd give it, but it's paragraph 515.
I think that this bundle has sort of broken all records for being out of sync with the numbers printed in electronic.
What I want to show you is table 5.1.
Okay.
And you will see that there you have retailers listed, showing that in the first column, so what I need is the share of DTP sales per grocery retailers by value in 2021. You will see their respective positions. The first 4 are dealt with are often known as the big 4. And you'll see how their share of DTP sales compares, and where those 3 retailers that I mentioned who use that means of sourcing their supply fit in the overall scheme of things, if I can put it that way.
Looking at the ranges in the second column, shares of PL within retailer.
Yes, some retailers, there are famous examples of this, don't do brands at all, or very, very few indeed. Simply do own label, or unbranded products. Discounters are famous for that sort of strategy. M&S for a long time had its own St. Michael, all the rest of it. But others, on the other hand, go much more heavily on branded products to the exclusion of own label. And others provide a balance. And you can see from those figures, the big four
are roughly half-half, give or take.
Offer that choice to their consumers and run both lines. And that is of significance when you think about the ability of various supermarkets to flex between channels. That is going to obviously arise only in the case of supermarkets who stock through both channels, and in particular the big four, where you can see it's roughly 50-50 thereabouts on those ranges which are given in the non-comp version. Obviously their ability to flex in that way will be very significant. And when you look over the overall volumes for which those are, those four even are responsible of overall sales, again, it's in the, if one added together the low band to the high band, it would be between 60 and 100%, but you can see more accurately than that than the actual figures.
Yeah.
But anyway, a large chunk of the market, if I can put it that way, has that ability to flex in that way. So that provides the background for completeness on supply process. The equivalent paragraph for branded is at 7.28. It's less complex. That's on internal page 84. You can see there's not evidence of tender processes being used for branded supply.
Turn to page
84, 7.28. You can see the process by which those products are supplied, less complex, entirely carried out by the supplier with little to no involvement by the grocery retailer. Not seen evidence of tender processes being used, understandably because of limited supplier options in the branded channel. So then you come to cross-channel competition. And this is important because there's some suggestion in my friend's skeleton argument, although he didn't use the word, I don't think, in his oral submissions, that this form of competition is indirect only, and that is a mischaracterization of the CMA's conclusions. And that, again, will be important. Can I start at bottom of page 84, same page, cross-channel competition. You can see at least a certain percentage, 70 to 80%, you can see where it lies within that range of DTP products supplied in the UK are sold by grocery retailers that provide both PL and branded products. They have a finite amount of shelf space and they have to decide how much will be allocated across the product range. And then there's some examples given of that evidence from the retailers. At 7.33, you see the conclusion that DTP products are typically close substitutes which compete for shelf space. 7.33, examples given of that. And 7.34, as such, there's an ongoing process by which retailers select their optimal volume mix of PAL and branded products to best serve their end customers and their commercial interests. We refer to this mechanism as rebalancing or flexing between PL and branded products. And over the page at 7.35, DTP suppliers will consider the impact of their offering across PQRS, price, quality, range, service, on expected volumes, which in turn drive profits. So the supplier is therefore incentivized to provide the retailer with a good deal, as the retailer may, one, switch to another supplier for that channel, or two, subsequently allocate more shelf space to the other channel. So as a result, there's competition between DTP suppliers, not only within each channel, but also across them. At 7.36, competition defined as being a process of rivalry between firms seeking to win customers' business over time by offering them a better deal, and reference to the competitive tension between DTP suppliers, both within and across channels, which incentivizes lower prices, increased output, improved quality, enhanced efficiency, new and better products, with periodic opportunities for suppliers to improve their offering for the terms included in the supply agreements, but more general efforts to boost efficiency, enhance quality and innovate constitute an ongoing process driving better outcomes for customers over time. Now switching, important context as well, particularly in the context of my own friend's new submission about market shares. Again, I'm laying ground at the moment, but internal page 97, paragraph 7.80. You can see switching within the branded channel is extremely rare. That's all I need from that. 7.81, switching of PL suppliers does occur, however, it does not happen frequently. Across 6 largest grocery retailers, there have been 5 instances of switching PL supplier in 6 years, and they were carried out by 3 retailers, one of which you've seen reference to, the most recent one. Parties provided no further examples of switching to suggest it happens more frequently. In addition, we've not seen any evidence that indicates that pandemic materially affected and that is developed. At 782, there's a consolidated customer base in this market. This is also true of suppliers. The parties' combined share will comprise almost, and then there's a proportion, of the total DTP wholesale market in 2023 by value, and 4 suppliers in total, those 4 you see identified, account for an estimated and something 80 to 90 share of wholesale supply of DTB in 2023 by value. When switching does occur, it may only relate to certain products or stock-keeping units, e.g., and then the example to which you've heard reference, which was limited to certain products only. And at 786,
did you just add, and it may be of no interest or relevance at all, puff pastry is what proportion, approximately, of the whole DTB?
It's the single most popular product. It's, I think it might be in a confidential box, but I can give it internal page 49. You'll see the diagram and the statistics for 2020 and 2021. The figure on internal page 49. So important within the market, but you can see the numbers of the various other products as well. And you can see that fastest growing is referred to in the text above. Oh, that's not complex. Pizza dough is the fastest growing sector.
This is all very confidential.
That is
confidential?
That's marked with a confidential box. So I'm taking it.
Right.
This has been through a process, and we can. There was a letter to the court. Can we provide that? Because I appreciate a number of questions have been
I
raised.
find it difficult to understand why that, I have to say, is confidential, because it's just, it's
Overall
supposedly
market.
the overall general trend of what sort of pastries people
I think it
buy.
may be the source from Nielsen statistics, but that is anyway the answer.
It's internal analysis of market data.
But from 7
If it's market data,
done that at all.
just somebody's analysis of it.
Of something that's published. Anyway, right, okay, but thank you. You've answered the puff pastry.
I've answered that question, even if I can't answer the next question. 786 through to 789 indicates the degree of ease with which it is to switch within the PL channel. And you can see that only 1 out of 9 said it was easy, that's 7.86. You can see who and where they lie in the overall scheme. Another thought it was in theory possible to switch with relevant ease. Again, you can see who and where they lie. But then you can see in the following paragraph, 5 out of 9 submitted it was either difficult or very difficult. And you can see the detail of what they said.
I mean, this may depend upon, in a sense, the retailer's offering. I mean, if a retailer offers a broad cross-section of the products we were just looking at, it might be more difficult to switch.
Yes,
reliably
exactly.
or otherwise. And if it's only offering one,
That's
if it's
exactly
only
right.
offering a bit of pizza dough, then it might be more straightforward.
Yeah. If you're only interested in buying a single type of product, take puff pastry for example, then it may be easier to find a supplier for that than if you are interested in sourcing pizza dough and other products as well.
Yeah.
So it may well depend. But this is the evidence that was gathered.
The context to this, in your view, is that the market's sticky.
Yeah.
That makes it difficult for someone like a Bell's or a Helgelin, even if they had capacity, to get traction into a retailer because there's an inbuilt resistance at that point. That's
inbuilt
the
resistance.
underlying.
And by contrast, what is much easier is 790 to 72, which is rather than switching to a new supplier, retailers may choose to switch volumes between existing suppliers, since supply agreements typically do not specify the volumes to be purchased. This can be varied at short notice, and switching volumes between existing suppliers is likely to be relatively easy and costless, and that can take place within the PL or branded channels if retailers use more than one supplier in each. However, it's unusual for retailers to have more than one supplier for a given DTP product type in each channel, and switching volumes between existing DTP suppliers therefore would typically occur across PL and branded channels through the rebalancing or flexing mechanism described above. And that's the important fact. That's where the main, as the CMA go on to find, is where the main competitive tension happens between those two channels. So any suggestion that the CMA found that this was indirect competition only and somehow this is to be minimised and not thought of as potent as direct competition, such as where two competing suppliers are going head to head in a tender exercise, we are not in that territory. That is not what is characteristic of this market. That's the essential point. So then when we come on to the competitive assessment,
So how does that work in practice? So just retailer X has historically 80% of its puff pastry is own brand, and it suddenly decides, and 20% is Just Roll, say. It suddenly decides that it's going to purchase 50% from Just Roll.
yeah, I mean, that would be quite an extreme swing, but yeah,
Yeah,
that
I
sort of
follow that.
rebalancing
Just-
that you've
yeah.
seen what the balance is more likely to be.
Yeah.
And that's precisely what the CMA go on to examine, exactly that question, because you
Yeah.
can see how important that is. And that is, if you like, the centrepiece of the analysis on.
Is there an assumption that customers are not actually that fussy about their pizza dough or their puff
Yeah,
pastry?
the answer is some will be, some won't be.
But they're not as fussy as in other types of products, for example.
Well, that would depend. But again, the key point, if you're looking at the big four supermarkets, which tend to stock both, they can still influence consumer choices because not only does volume and shelf position and display or promotion, in particular discounted special offers, it can influence the choices. Now, some customers may be acutely price sensitive and only ever go for own label products. Other customers might have more disposable income and perceive that they're getting a better quality product if they go for the branded option. Others may well themselves flex between the two. And the fact that retailers flex between the two in the same way to manage their supply and demand shows that they're responding not only to customer preferences, as we saw earlier, but also to their own commercial considerations, such as the profitability of individual products, the desire to have the range, the desire to innovate and so forth and have multiple products. So multi-fact, but these are sophisticated customers. I mean, these supermarkets obviously have very sophisticated operations. So the closeness of competition is then analysed in section 9 as part of the competitive assessment, in a section headed closeness of competition, which begins internal page 124, 9.15. And again, because it's no longer in issue, though it very much was below, I'll skip straight to the conclusions, but just to note there's a vast amount of analysis which goes into this. The conclusions then begin at paragraph 9.150, which is at internal page 180. And there is much detail along the way, needless to say. The conclusion at 9.150, we found that parties compete in the wholesale supply of DTP products to retailers. That's a reference back to the market definition conclusions, in essence. Physically similar substitutes. Significant degree of overlap, high levels of supply-side substitutability. as the 9151, supply process differs, with the PL channel typically requiring a more iterative negotiation process between retail buyer and contract manufacturer, while branded suppliers often on take it or leave it. And so for that reason, they don't compete head to head in the same tender processes, a point fixed upon by Cérélia in its written argument in particular. However, we have found that there's nonetheless competition across the channels such that they do compete, and the evidence from third parties indicates that the parties are close competitors. While some suppliers were focused on within channel competition, third parties generally considered Cérélia and Just Roll to be competitors. The largest retailers that make up a large majority of the overall market articulated a consistent and coherent view that there is an implicit but important constraint between the parties which will be lost as a result of the merger. In particular, they explain that they value the ability to weigh up the parties' offerings across the PL and branded channels in order to get a better deal in negotiations, particularly in terms of price and quality. Now, that summary paragraph and all the evidence that goes before it was the subject of sustained attack in the tribunal before. The court will have seen the judgment about that. Needless to say, just simply upheld the conclusions on that, but a vital conclusion. Further strengthened at 9153 by the parties' internal documents, showing that they monitor each other and regard each other as competitors. Documentary evidence of the constraint between Cérélia and Just Roll influences market outcomes and negotiations with retailers at the wholesale level in a way that is consistent with the constraint described by retailers. There's particularly strong evidence that GMI regards PL products as the primary competitive constraint on Just Roll. We've found overall there is strong evidence that PL and branded products are similar products which compete closely for end consumers at the retail level. We consider that this extensive evidence of close competition at the retail level is an indication of closeness of competition between the parties at the wholesale level. We also consider the vertical link, and we recognise the role as a contract manufacturer is likely to have had some effect on the extent of competition between the parties pre-merger. That doesn't mean there can be no SLC brought about by the merger, and consider that the merger would result in material changes in competitive dynamics and market structure. And in the round, we consider that the evidence supports the view that there's material competitive interaction between the parties. This competition between the parties would be removed by the merger, thereby reducing the ability of retailers to protect themselves against potential price rises by a particularly large supplier with full control over PQRS in both supply channels. However, in keeping with the position set out in our guidance that closeness of competition is a relative concept, the significance of the competitive constraint the parties exert on each other also depends on the strength of the constraint from other competitors. The loss of competition between the parties must therefore be assessed in the context of the alternative competitive constraints that they face, and that's how we get the alternative competitive constraints. What is said there equally works, if you like, in reverse when considering the strength of the constraint from other competitors and whether it's rational to conclude that that is limited. That has to be seen in the context of whether it's going to be enough to mean that despite everything which has gone before, there will be no SLC, despite the removal of that competition by the merger and the reduction of the ability of the retailers to protect themselves against degrading in PQRS. So that is the framing and the context. And so if it's
right to say there's no quantitative analysis of the effect of the
no,
merger.
it's qualitative.
It's entirely qualitative. Yeah. There's no HHI analysis or anything like that.
No, and indeed that wasn't considered necessary. There were some questions about that below, but in the end that wasn't a point taken by Cérélia in this appeal. So there's no objection to the fact that it was a qualitative assessment. And
so just to put it in context, your first part of the analysis is to work out how much competition evaporates as a result of the merger. So this is the analysis here. Then you've got to be satisfied that if there are alternative constraints, whether new entry or retailers or third parties, they're sufficient to negate that SLC that you've identified here, not quantified, but qualitatively described.
exactly. So before a formal finding of SLC, there's a consideration of the alternative competitive constraints, and then which I will also touch on tomorrow, a consideration of the effects of the merger in terms of the effect on the incentives of the merged entity to degrade either the branded product or the PL product or both, just notwithstanding the vertical link. And this will be important because although my learned friend's new point, which he seeks leave to admit, is attractively and simply put, there is a world of detail under this as to why you can't simply say, oh, well, look, if you've got a certain proportion of the PL market, you can continue to compete against other PL suppliers, and that will constrain. No, it's not as simple as that. If the point had ever been raised before the CMA, no doubt there would have been a reasoned answer to it expressly. But the reason why it's not something which the court can take a view on, on the basis of the documents that we have, is that this is an acutely context-sensitive and difficult analysis based on qualitative judgments on the basis of a detailed appraisal of the market as a whole. And I've skipped over in getting to closeness of competition for the interest of time, but of course the other factor, which again we'll come back to tomorrow, at the very outset of the competitive analysis, just before closeness of competition, is the shares of supply. And you see that in particular at the table, which the court has already seen, internal page 1, 2, 3, the shares of supply each had. But the key point there, which you can take from that, is it's significant that it's the biggest player in each channel which are emerging, and the overall market share which will be arrived at is obviously in the 60 to 70% bracket. Then we can come on to questions of, well, what happens if they lose some of the business, which I'll come on to tomorrow. But it's simply, we say, once you've got to the position of having a single product market covering both channels, in which products compete with each other at a wholesale level across those channels, it makes no sense to simply say after that, after post-merger, you can somehow continue to analyse these as separate products and separate markets, which need to be considered separately, with market shares broken down in the way suggested by my learned friend. It makes no sense once you've got a merged entity which can itself flex between the two, which can itself offer promotions on one or the other, which can itself may have incentives to degrade one against the other.
Well, to the extent of competition.
Yeah.
It just picks it off, doesn't it? Depending on...
Again, I appreciate I've taken an hour to set the scene, but that hopefully will speed me up.
Okay, is that a convenient
Tomorrow,
moment?
if that's a convenient moment for the call.
10:30 tomorrow morning, Chris. Thank you.
All right.